The corruption case of former National Assembly Speaker Nosiviwe Mapisa-Nqakula will be heard in the High Court in Pretoria on the 16th of October. The case will then go through pre-trial proceedings until it is ready for trial. Mapisa-Nqakula this morning made a brief appearance before the Pretoria Magistrates Court where an indictment was served. The former speaker is accused of soliciting 4 million rand in bribes from a defence contractor during her tenure as Defence Minister. She faces 12 counts of corruption and 1 of money laundering. All right, for more on this, we are now joined by Law Expert Mpumelelo Zikalala for this and other legal matters. And thank you so much for your time this afternoon, Mpumelelo. Today's court case was, of course, very brief. Let's start with the indictment that was then served this morning, which gives a sense of the alleged bribes, the former speaker, Mapisa-Nqakula, solicited from the defence contractor, of course, allegedly, which apparently started when this 104 million rand tender was suspended.
Definitely, we must look at the indictment as a much more comprehensive list of charges to say, ma'am, these are the charges that are going to be preferred against you. We're giving you enough time so that when you appear in October at the High Court, you would have already prepared the list of witnesses and the documentary evidence which you might need, so there are no delays when you conduct the pre-trial to determine the state of readiness of both parties. But it proves that the state does really have a case that it is created against the former speaker. So to say that there was a weak case, to say that there was no evidence that proves what the state is saying, I think they may be singing a different tune now. But the evidence is going to be the one which is going to tell a much more detailed story. Once the witnesses start going into that witness box, once those documents are then presented in court, it is only then you can determine whether the former speaker is something that they need to answer to and whether the High Court is indeed the appropriate forum you should deal with, which must be an indication, by the way, that if you move from the Magistrate Court to the High Court, the seriousness of the charge and also of the sentence that you're going to get is also going to be one which is going to be very high.
And I want to touch on that move, So we, of course, heard in the Magistrates Court that this case is going to be moved, as you rightfully say, to the High Court in Pretoria on the 16th of October. The case will then go through pre-trial proceedings until it is ready for trial. Just explain that whole process for us in terms of what are we then likely to expect in a pre-trial, for instance?
Well, after receiving the indictment, which is your charge sheet, you then go and say, these are the witnesses in which I'm going to bring, which are going to prove what I'm saying as the accused. I also want to see what the state has got against me. If there are certain documents that must be handed over to me at a much earlier stage, please do so that I can take it over to my team and they can be able to discuss it. So in the pre-trial simply says that check the status of readiness of both parties, how many witnesses are we likely to bring, how long must we set this matter down for, are we going to need any interpreters, is there any expert evidence which is going to be required, are there any special dates in which we need to secure. So it's all those things which are going to help the trial to move at a much more smoother pace, which are then discussed at the pre-trial hearing. And then after the pre-trial, and once the matter has been set down for more than 1 day, then you can expect to see a number of witnesses going to the witness box.
And I mean, you speak about just the evidence that will probably come out when this, goes to the High Court. I mean, what are we likely to see? We know, of course, that we have possibly a witness in the contractor at the time, Nzodwa Ndlovu. We know there's a Schedule A that was, included in the indictment that speaks about certain gratification payments that were made, as well as the locations of these, monies that were supposedly exchanged. What are we likely to see there in terms of what the state is likely to show, from evidence perspective?
Definitely the flow of the money, to say that money came from Department A, it then went to the service provider, from the service provider, it then went to the former speaker's account or utilization. And then the question would be, former speaker, what were you utilizing the money for? Was it a loan? If it was a loan, when were you going to pay it back? Why does it so coincide that whenever you have exerted your executive powers and your influence in this particular department, certainly the one that maybe you were exercising ministerial positions over, then this person gets this particular tender. So what's going to be looked at is, when the tender was issued and services were then agreed to, did the service provider really qualify to provide for those services? Secondly, when the money came through, it was there value for money, or were the prices inflated? When those funds were then paid, how then did it come about that the funds land into the bank accounts or into the possession of the minister? It shouldn't work like that. Whenever a person is working, it must be an honest payment, and the minister has no business in terms of the service providers that are within their department. So if it is found that there's a flow or a link of money from the department to service provider and then to the minister, then an inference can be drawn to say you have exerted your powers, you've shown influence over the officials that were there. They handled and managed this process at your instructions, and all that you wanted to do was to financially benefit from what we have now, whether financially or non-financially. But at the end of the day, as you exerted that influence, there's something that you got, and that is against the law.
But just remind us again, in the event, of course, where somebody turns a state witness, we know, of course, that the businesswoman Nosiviwe is now, state witness, and she is, of course, going to be, appearing on trial, I would imagine, on behalf of the state. Mm-hmm. What are the prescripts from a legal perspective and the benefits that she will then, enjoy from this position that she sits in? Just bring us up to speed again from the legalities perspective.
You'd find that there's a plea bargain that has been entered between the state and her. So the state will come and say to her, you see, if you tell the truth and you help us nail the former speaker, you are going to get a lesser sentence. You would have received maybe 25 years or even a fine. Even your assets might have been forfeited, but because you're going to be part and parcel of our case, we can plead and then say to the court, let's give them a suspended sentence and notify them at all. But in return, you must tell all, because you're the one that was involved and had the intimate details of what was happening. Go into the witness box and state that I spoke with her on this particular day. This is the person that she has sent. We spoke on this particular tender. I filled it in. I made the submission. I did not qualify. I knew that I did not qualify. However, I was paid this amount of money. And so to stay true to what I promised her, I then made certain payments over to her account, whether directly or indirectly, and even paid for some of the services that she might have procured. So once you've state witness, you are basically saying, I'm going to be the one person or the star witness that is going to tell all as to how the chain of money or the flow of money moved from the department to me and also to the person that is on trial. And that particular transaction was not an honest one. It was fueled by corruption. It was fueled by one person seeking to benefit. And there was a beneficial relationship that did exist. So on that basis, it then increases the chances of the state coming back with the guilty verdict against the former speaker.
It will be interesting to know if, this also exempts her from any other possible legal, challenges that she might face as a state witness, for instance, from the department. But let's move ahead now. In her bail application, the former speaker had indicated that she feels that the state's case is exceedingly weak. I mean, what could her, legal team's strategy be?
Maybe at the time she made that determination, I think it was too early. The only time that you can make the determination is when you now have received the indictment, you've received the supporting documents, and you're looking and preparing for the case, and you can see that this is a witness that cannot be relied upon. So to make that determination at an early stage, I think maybe it was a bit ingenious of her and needed some sort of help or assistance. But I don't think that that would be a position that can be able to arrive at.
Mpumelelo, thank you so much for your time and, of course, your analysis. Law expert Mpumelelo Zikalala there for us.